Imagine a single corporation controlling the very gateway to the internet, dictating who could enter and what they could see. In 1998, that was the actual fear, and it led to the most significant antitrust trial of its era. United States v. Microsoft. The Department of Justice, along with 20 states, alleged Microsoft used its Windows operating system to unlawfully stifle competition, particularly against Netscape Navigator, essentially attempting to monopolize the nascent web browser market. This wasn't just about market share. It was about the fundamental structure of the Internet. The court's findings of fact, filed as Civil Action No. 98-1232, TPJ, focused directly on Microsoft's leverage through the application's barrier to entry. This case fundamentally reshaped how we understand corporate power in the digital age, with implications still felt in 2026. In 1999, former Federal Trade Commissioner Orson Swindle stood before the Federalist Society and, speaking about the then-ongoing trial against Microsoft, stated plainly that the case was about ensuring competition in the most dynamic, innovative, and important sector of our economy. This was not hyperbole. By the late 1990s, Microsoft's Windows operating system powered over 90% of all personal computers worldwide. Its browser, Internet Explorer, was bundled directly into Windows, virtually eliminating competitors like Netscape Navigator. The sheer scale of this market dominance, and the tactics employed to maintain it, sparked an unprecedented legal challenge. A challenge that, in many ways, continues to shape our digital landscape a quarter-century later, as seen in the recent Google antitrust trial. Today, we delve into United States v. Microsoft, a monumental antitrust case that began on May 18, 1998, when the U.S. Department of Justice, alongside 20 states, filed suit against Microsoft Corporation. The core allegation was that Microsoft had systematically abused its near monopoly to stifle competition. On May 18, 1998, the U.S. Department of Justice, joined by 20 states, including New York ex-rel. Attorney General Eliot Spitzer, filed antitrust actions against Microsoft. The central allegation was that Microsoft was unlawfully leveraging its dominance in the operating system market to stifle competition, most notably by bundling its Internet Explorer web browser directly with its Windows operating system. This move, the prosecution argued, effectively crippled rivals like Netscape Navigator, founded in April 1994 by Jim Clark and Mark Andreessen, whose own president and CEO, Jim Barksdale, would later become a key witness. Barksdale's testimony highlighted the intense browser wars of the late 90s, where Microsoft's strategic integration of Internet Explorer made it nearly impossible for Netscape to compete on a level playing field. The case was heard before Judge Thomas Penfield Jackson, whose comprehensive findings of fact focused heavily on Microsoft's immense market power and what the court termed the application's barrier to entry, a significant hurdle for any potential competitor to overcome due to Windows ubiquity. This barrier, according to the court, locked users and developers into the Windows ecosystem, making it difficult for new operating systems to gain traction. The legal battle culminated with a landmark decision by the United States Court of Appeals for the District of Columbia Circuit on June 28, 2001, found at 253 F3D 34. This case didn't just target a single company. It fundamentally reshaped how regulators viewed the digital landscape and set the stage for how future antitrust battles would be fought against tech giants. This precedent, the ghost of antitrust past, continues to shape today's tech battles. The ghost of this antitrust past, as Jacqueline Diaz for NPR Illinois recently noted in April 2025, continues to exert enduring influence a quarter-century later, its specter looming over the very definition of market power in the digital age. The precedent set by United States v. Microsoft, ultimately decided on June 28, 2001, by the United States Court of Appeals for the District of Columbia Circuit, are absolutely critical in shaping today's legal battles, particularly the ongoing Google antitrust trial. This landmark case effectively defined what constituted a monopoly in the nascent software industry and how the tying of products, specifically, Microsoft's bundling of its dominant Windows operating system with its Internet Explorer browser, which captured over 90% of the market share, could be deemed anti-competitive. The exhaustive legal proceedings, including a detailed bench trial before Judge Thomas Penfield Jackson, established a clear benchmark for proving market dominance and anti-competitive practices, providing a foundational playbook for tech regulation that would be referenced by subsequent administrations. As former Federal Trade Commissioner Orson Swindle stated to the Federalist Society in 1999, the world was already focused on holding tech giants accountable. This scrutiny, far from diminishing, would only intensify, leading to a new battleground: data privacy, cross-border warrants, and the increasingly complex international waters of digital commerce. But the story of United States v. Microsoft isn't confined to the turn of the millennium. A far more recent, and equally significant, legal battle emerged, this time centered on data and digital sovereignty. In 2013, the U.S. government served a federal warrant on Microsoft, demanding the email contents of a customer whose data was stored on Microsoft's servers in Ireland. The warrant was issued under the Stored Communications Act, part of the Electronic Communications Privacy Act of 1986. Microsoft, while complying with requests for non-content data stored within the U.S., firmly declined to produce the customer's actual email content held in Ireland. The company argued that a U.S. warrant, by definition, has no extraterritorial reach. This refusal challenged the very scope of U.S. law abroad, particularly as it applied to the vast and borderless realm of cloud computing. This case, often referred to as Microsoft v. United States, became a pivotal dispute over where digital jurisdiction truly lies. It presented a complex question. Does a federal warrant compel a U.S.-based company to produce customer data stored on servers outside U.S. territory, even if that company operates globally? The implications of this question set the stage for the warrant, issued under the Stored Communications Act, demanded access to a user's emails. Microsoft, after producing non-content information stored in the United States, refused to access the customer's content stored on its servers in Ireland. This refusal set the stage for a critical modern legal battle, directly posing the question of whether a U.S. warrant could compel a company to retrieve data from a foreign server, potentially violating the data protection laws of another sovereign nation. This modern U.S. v. Microsoft case, which some analysts suggest could see further re-examination or impact decisions around 2026, squarely forces a collision between national sovereignty and the global, borderless nature of cloud computing. The potential fallout from this dispute, the concept of how one company almost broke the Internet 2026, underscores the profound implications for digital commerce and privacy. The resolution of this case could establish critical precedents for data jurisdiction, fundamentally altering how all cloud providers handle data stored across borders and what legal mechanisms governments must use to access it. This legal challenge has the power to redefine global data privacy, security, and the operational freedom of multinational tech companies, with profound effects on users worldwide, directly feeding into the enduring legacy of why Microsoft still matters. This dual narrative, from the antitrust battle of 1998 to 2001 to the international data privacy clash of 2013, solidifies Microsoft's enduring role in defining the legal boundaries of technology. The initial antitrust case, filed on May 18, 1998, with plaintiffs including the United States of America and the state of New York ex rel. Attorney General Eliot Spitzer, fundamentally shaped how governments approach market dominance. It influenced subsequent regulatory considerations for Google and other tech giants, particularly regarding the application's barrier to entry cited in court findings. The later challenge, stemming from a federal warrant served in 2013, pushed the very limits of legal jurisdiction. The D.C. Circuit's decision on June 28, 2001, in the antitrust case, cited as 253 F3D3, provided a framework for understanding market power that has resonated for decades. Now, the International Data Privacy case tests the reach of the Stored Communications Act in a world where data resides globally, challenging our understanding of digital sovereignty. These cases consistently highlight Microsoft's role in shaping the Internet's legal infrastructure, from its early growth with Windows and Internet Explorer to its current cloud dominance. Understanding these distinct, yet equally crucial, U.S. v. Microsoft cases is essential for grasping the complex interplay between innovation, regulation, and global governance in the tech world. Retrieve data housed abroad. The U.S. government argued that the location of the data was irrelevant. The company itself was a U.S. entity and thus subject to U.S. warrants. Microsoft countered that compelling them to retrieve data from a foreign server would violate the sovereignty of other nations and potentially conflict with international law. This particular legal dispute, known as Microsoft Corp v. United States, eventually reached the Supreme Court. However, the case was ultimately rendered moot when the Cloud Act was passed in 2018, providing a new framework for law enforcement to access data across international borders with cooperation from foreign governments. What the two cases of United States v. Microsoft illuminate is not merely the historical record of a single corporation, but the continuous, often preemptive struggle of legal frameworks to contain the implications of technological advancement. From market dominance in operating systems to the complex landscape of global data sovereignty, Microsoft has consistently found itself at the nexus of defining what is legally permissible in the digital realm. The questions these cases posed, about monopoly power, about data jurisdiction, and about the very nature of digital evidence, continue to shape the Internet we experience in 2026 and will undoubtedly influence its evolution for decades to come. Considering the global reach of today's tech giants, how do you believe international data privacy and law enforcement demands can be effectively balanced without compromising national sovereignty? Share your perspective in the comments below. For more detailed analyses of cases that redefine the boundaries of technology law, make sure to subscribe to this channel. And if you found this breakdown insightful, you'll want to watch my deep dive into the legal challenges posed by emerging AI technologies next. This video presents publicly documented information. It is for educational purposes, not legal advice.